Cause, oh,
Good morning. This is PSC docket number 25-0037. It is a water-based rate case filed by Veoila Water Delaware, Inc. My name is Mark Lawrence. I'm the senior hearing examiner at the commission. I was appointed by the commission in order to handle this case. This is a continuation of the evidentiary hearing in this matter, and I'm going to begin by taking appearances of the attorneys. I will begin with the company.
Good morning, Your Honor. My name is Shane Simon from Saul Ewing LLP on behalf of the company.
And I'm Pam Scott with Saul Ewing LLP on behalf of the company.
Commission staff.
Kate Workman on behalf of staff.
Stephen Ferguson on behalf of staff.
Public advocate.
David Crumpler on behalf of the public advocate.
Before having the company call its first witness, is there anything that the parties need to discuss on the record?
Staff would like to make a motion to reconsider.
Okay.
Our motion to reconsider is regarding our motion that we had filed prior to this regarding the testimonies of Walker and Fetcher, asking that they be stricken. And the hearing examiner gave us a ruling on Monday in which the hearing examiner ruled that both would be permitted today. I wanted to bring up that from staff's point of view, it is wholly unfair that the company is able to, on their rejoinder testimony to which staff, again, has no response, it's to bring in new facts and figures. 26 Delaware Admin Code 1002A 1.3.4 requires that expenses offered by the utilities have to be provided prior to or with rebuttal evidence. So my understanding of that is the rebuttal evidence is likely the rebuttal discovery period. And after that is essentially when things need to cut off. And instead here we have both Walker and Fetcher providing updated numbers, updated figures to which, staff is only just receiving for the first time, is very far out of the test period. And staff believes that having to deal with these new facts and figures and these witnesses today is wholly unfair to both staff and the DPA, and we would request that both Walker and Fetcher's testimonies be not admitted into the record. Thank you.
Company.
Thank you, Your Honor. I think Your Honor should deny the motion for reconsideration for the same reasons stated in your order denying the original motion. First of all, there is not new information or data. As we stated in our response to staff's original motion with respect to Mr. Walker, Mrs. Odd, through her rebuttal testimony, opened the door for him to respond to her new positions concerning the company's risk and rate of return as it relates to the PFAS mechanism. Excuse me. Second, with respect to the rate case expenses, that information was provided with respect to rebuttal in those updates, so that's not new information. And then with respect to Ms. Fetcher's testimony, again, as argued and as found by Your Honor, that information is not new. It's corroborating existing information that was presented, again, prior to or with rebuttal evidence concerning the date ranges. To the extent that Your Honor is considering granting these motions, we don't think it would be appropriate to preclude the entirety of their testimony because, again, the entirety of their testimony does not relate to these alleged new components. And finally, with respect to the fact that it is rejoinder testimony, at some point someone has to have the last word, and as the entity with the burden of proof, The company submits that it is proper and appropriate for the company to have the last word on these issues since it must carry the burden.
Public advocate.
Nothing further to add. I think staff's point is well placed, and we'd agree with it.
I'm going to deny staff's motion for reconsideration for the reasons described in my order on Monday. Thank you. Company, you may call your first witness.
Thank you, Your Honor. The company would like to call Miss Mary Ann Hatch. Miss Hatch is appearing via Zoom this morning.
Please swear her in.
Mary Ann, can you raise your right hand, please?
Ms. Hatch, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalties of perjury?
I do.
May I proceed, Your Honor?
Yes.
Thank you. And for the record, I previously distributed, before we started today, copies of Ms. Hatch's rejoinder testimony. Ms. Hatch, good morning.
Good morning.
Do you have a copy of your rejoinder testimony in front of you currently?
I do.
And that is the rejoinder testimony that you submitted in this proceeding, correct?
Correct.
If you were to give the questions and answers in that rejoinder testimony here again today, would you change anything in that rejoinder testimony?
No, I would not.
And are there any errors or omissions that you need to correct in that rejoinder testimony today?
No.
Thank you. At this point, Your Honor, the company would move for the admission of Ms. Hatch's rejoinder testimony, as I believe we are at Exhibit 91.
I have Exhibit 90.
Be the fully executed partial settlement agreement.
Okay. That explains it. Okay. Any objection from staff?
No.
DPA?
No objection, Your Honor.
Okay. Admitted as Exhibit 91 is the rejoinder testimony of Mary Ann Hatch.
Thank you. No further questions for Ms. Hatch on direct.
Cross staff?
Thank you, Your Honor. Ms. Hatch, can you hear me?
I can.
Okay. When we're talking about PFAS O&M costs, what does the O&M mean?
I believe that has been stated in my testimony, and generally speaking, it is related to the media change-out costs, which are required to remove the PFAS from the water, as well as the freight in and freight out.
I guess what I'm getting at is what does the O&M stand for? Like, what is that a acronym for?
Generally speaking, O&M stands for operations and maintenance expenses.
And just generally, not specific to the PFAS costs, what kinds of expenses are in the O&M category?
I think that you could easily look at the exhibits that the company has filed in terms of the O&M expenses, but just at a very high level, you would have things like, chemical expenses, electricity expenses, wages and salaries, so on and so forth.
And the O&M costs are included in the rate base, is that correct?
The O&M costs are not included in the rate base, they're an expense. Rate base is what's in service and returns a return of and on.
But the O&M costs are included in the revenue requirement, is that correct?
Correct.
And you would agree that the PFAS O&M costs will persist indefinitely? that correct?
I believe that is consistent with the tone, the testimony that has been provided thus far in the proceeding.
And you would agree that the immediate change out for the Stanton Water Treatment Plant will occur on a regular basis moving forward. Is that correct?
Moving forward over time as we move into normal operations for the new PFAS treatment facility, yes.
Are PFAS, the PFAS, and the PFOA the only contaminants that Veolia must remove from the water?
I don't believe I spoke to that in my testimony.
But it discusses PFAS and PFOA and how these costs are so extraordinary that they deserve special treatment. I'm trying to compare them to how other um, items are treated. So, what other contaminants other than PFAS and PFOA um, does the company have to remove at the Stanton Water Treatment Plant?
I'm not a water quality expert, nor am I an operations expert. But I would imagine that there are other things that need to be removed from the water to ensure that our customers receive safe, adequate drinking water.
So, is removing contaminants or otherwise treating the water for contaminants unusual for a water utility?
I think that those contaminants is, again, I'm not a water quality expert. I'm not intimately familiar with all of those water quality regulations. But I would also say that, um, can you repeat the question again?
Yes. Is removing the contaminants or otherwise treating water for contaminants unusual for a water utility?
Well, I think again, I'm not a water expert, and I'm not going to pretend to be one. Generally speaking, it is part of the mission of the company of a water purveyor to make sure that water is safe and reliable. To the extent that removing these kinds of already established contaminants during the course of normal business, those things may not necessarily be unusual. I think what makes the distinction here, however, is that this is the first time that MCLs have been established for PFAS contaminants, either by the state or by the EPA. And so this is the very first time that any water utility is being required to remove PFAS contaminants in and of themselves.
Now, is removing those contaminants or otherwise treating the water for contaminants infrequent for a water utility?
Can you say the question again, please?
Yes. Regarding the contaminants, just generally,
Mhm.
and treating for contaminants generally, is it infrequent for a water utility to treat for those contaminants?
I do not know the answer to that question. I'm not a water quality or treatment expert.
But your testimony goes into at length how extraordinary and um, out of the ordinary it is for such water treatments, but you're unable to answer questions about other water treatments.
The discussion around extraordinary has much to do with the fact, as I already said, that it is highly unusual that the EPA in the state now has MCLs for PFAS. As I clearly state in my testimony, and if you give me a chance, I can refer to it. But generally speaking, this is the first time that these MCLs have been established for the entire water industry. This is the first time in a very long time that there's been such a significant change to the SWDA, so the Safe Water Drinking Act. So in that respect, in many instances, removing these PFAS contaminants in this instance, this is extraordinary, not just for this company, but for the entire water utility industry.
Does the source water that Veolia processes not currently go through a vigorous treatment process?
Again, I'm not a water treatment expert, but again, we do meet the requirements. We do meet all the goals of providing safe, reliable water. And so with that comes treatment of I would suppose, again, I'm not an expert, of contaminants that have already been long established.
And that happens on a daily basis, correct?
I mean, in terms of like day-to-day operations, yes, the extent to which these kinds of contaminants are newly identified, or the magnitude of those contaminants, or the health and safety risks of those contaminants, again, I am not an expert in those areas.
Would you agree with the statement, PFAS treatment at the Stanton Water Treatment Plant is too new for routine operations?
Can you say that again?
Yes. Would you agree with the statement, PFAS treatment at the Stanton Water Treatment Plant is too new for routine operations?
Well, I think that it's kind of a tricky answer, because if you remember, this is the first time that the company or anybody in the water industry is being required to remove PFAS to non-detect levels. This is entirely new for the industry. Therefore, we have a new plant that's been put into service. And once you put a plant into service, you need to get that plant up and running. And then once it is up and running in normal operations, you will then have treatment that becomes more and more normal over time and with experience.
So if you could turn in your testimony, your rejoinder testimony, to the question posed on page 19, starting on line 1.
Okay.
An underlying assumption of that question that you go to answer is that the PFAS facilities, and I'm looking particularly at line 4, the facilities are too new for routine operations. Would you agree with that statement?
That is what that statement says.
But do you agree? Is that a true statement to your knowledge?
In the context, yes. And again, this is exactly what I was going back to before. It's you set up you establish a new plant, and as you go, you start going through normal operations, then things start to become routine. And I think that was discussed in Gila Fetcher's testimony. I think it was also mentioned in the testimonies of Cosgrove and um, Mr. Murray, talking about how when you go forward, you will have to make these change outs indefinitely.
So, according to you, the PFAS treatment at the Stanton Water Treatment Plant is too new for routine operation, but the company's position is that the PFAS media change-out expenses are reasonably known and measurable. Is that correct?
Yes.
Looking again on page 19 at lines, I'm sorry, page 20, particularly lines 5 and 6. You say that the company's obligation to treat PFAS is not of its own making, and the company did not cause PFAS to be in the drinking water supply. Is that correct?
That is what it states.
To your knowledge, did the company cause any of the other contaminants that they have to treat for?
I do not know.
Would you agree that regardless of whether the company caused a contaminant, that should not determine how expenses are treated in the rate case?
Can you repeat the question?
Yes. Would you agree that whether the contaminants are caused by the company or not does not determine how the expense should be treated during rate making?
I don't know that I understand the question.
So for purposes of rate making, does it matter who caused the problem the company must fix?
Well, I think that rate making, as we all understand, is both an art and a science. I think that rate making is more than a simple accounting exercise. I think that rate making should not only consider cost, but understand the broader context in which costs are actually incurred, underlying policies, and the realities of why those costs are being incurred and the impacts of those costs and the benefits that are conveyed to the customers of those costs.
But should we take into account whether or not the company caused the contaminants? Or should all contaminants be treated similarly?
I don't understand the distinction between one contaminant versus another.
Well, in my question, there is not a distinction. Regarding treatment for contaminants, does it matter if the company caused it or not for purposes of rate making?
Again, I would go back to the answer that rate making is part art and part science. And again, I think that you need to look into the underlying nature of the cost drivers and why they're even being incurred in the first place.
Thank you. During the time of the test period, how many times was the PFAS media changed out?
As stated in the testimonies of Gayla Fetcher and I believe also of Jenna Labella, none.
And you would agree that the frequency of media changeouts is a variable, correct?
Yes.
On page 8, I'm sorry, page 16, lines 1 and 2, you state that media changeouts will soon begin to occur in the rate effective period. Does that mean that media changeouts did not occur prior to this?
Again, I think that has been established in the record. Yes, they have not incurred. And my understanding, and it's been consistent throughout the record, that the media changeouts are expected to commence this spring. And in fact, in our testimony, it's stated April 2026. And to the best of my knowledge, these changeouts are beginning to incur.
I'm looking now at page 25. Lines 18 and 19, in which you state that not all situations can be anticipated or expected as a reason why the commission should grant special rate making treatment for PFAS O&M costs. Is that correct?
Objection to form. That is not, that's a quote from Ms. Hatch's testimony. She's quoting a commission decision. That's not her own words.
But she chose to put it in her testimony.
Yeah, but you said she stated it, so I'm just correcting the record.
So she stated it.
Stated it.
She put it in her testimony, whether it's a quote or not.
Just clarifying the record.
Overruled.
Let's start again. You state not all situations can be anticipated or expected as a reason why the commission should grant special rate making treatment for PFAS O&M costs. Is that correct?
What lines are you on?
I'm looking at page 25, lines 18 and 19. So it starts halfway through 18, the
Okay.
beginning of the sentence. Not all situations can be anticipated or expected. And the commission should not perforce categorize such situations in deciding regulatory asset applications. And that is in the context of, this EFOS and then you say the same rationale applies here for requests for riders, surcharges, or other rate making tools. So for the special rate making treatment the company's seeking for PFAS O&M costs,
Well,
one of the
I
reasons
see the
given.
quote, I see the quotation. I'm not sure what the question is.
I'm asking if that quotation as a reason why the commission should grant special rate making treatment for PFAS O&M, whether you agree with that. So as a reason why the commission should grant special rate making treatment for PFAS O&M is because not all situations can be anticipated or expected. Is that correct?
Well, the entire quote says, the water utility remarked that, starting at line 16, in considering applications for approval of regulatory assets, the commission has discretion to make its decisions on a case-by-case basis. Not all situations can be anticipated or expected, and the commission should not perforce categorize such situations in deciding regulatory asset applications.
And my question is, you would agree that that quote that you just read supports your claim that the PFAS O&M costs in this case should get special rate making treatment. Is that correct?
If you follow that quote again in line 20, my testimony says the same rationale applies here and to request for riders, surcharges, or other rate-making tools. I go on to state that it is well recognized that rate making is commonly considered an art, not a science.
So is that, are you agreeing or not?
I think my testimony speaks for itself.
Well, then I'm going to ask the question again because you still haven't answered it. That quote, does it support the idea that the commission should grant special rate making treatment for the PFAS O&M costs in this case?
Yes.
Yes. Oh, you said yes.
Yes.
Thank you. Now, if the PFAS O&M costs cannot be anticipated or expected, then they cannot be known and measurable. Is that correct?
Can you say that again?
Yes. So if the PFAS O&M costs cannot be anticipated or expected, then they can't be known and measurable, correct?
I mean, I suppose they could be contemplated. I can't answer that question.
That's okay. We'll move on. For the next set of questions, I'm going to be referring to the Chesapeake Utility Corporation versus Delaware Public Service Commission, citation 702A2D 1059. the case from 1997. Do you have that in front of you?
I do.
Okay. So to your knowledge, in this case, did the CERCLA, and that is the CERCLA, which is the Comprehensive Environmental Response, Compensation, and Liability Act, so did the CERCLA CERCLA cleanup in the Chesapeake case require ongoing O&M expenses?
Is the question around the O&M expense piece?
Yes, so the act that relates to the Chesapeake case, the CERCLA CERCLA Act, did Chesapeake's cleanup require ongoing O&M expenses? I don't know is a perfectly acceptable answer for anything I ask.
No. Well, generally speaking, the costs in question in this particular case were related to remediation costs.
So did they require an ongoing O&M expense?
In that particular case, what was at issue were these remediation expenses, some of which had already been incurred, and some were projected to be incurred over 30 years. And what was at issue in that case was not the fact that the commission had allowed a special rate mechanism, a surcharge mechanism for these costs, but rather what was at issue in there was whether or not the commission erred in allowing for recovery of the carrying costs.
To your knowledge, in
I don't
this
know.
case, did they require ongoing O&M expenses to comply with CERCLA, CERCLA?
I don't know the specifics of that distinction.
Okay. So on page 22, starting at line 16 in your testimony, the rejoinder testimony, you reference footnote 7 from the Chesapeake case. Is that correct?
Can you point me to the line or the reference?
Yeah, so page 22, line 16, starting in a footnote, the court commented, and then on 17, you get your footnote 60.
Okay.
It references footnote 7 from the case.
Okay, I see where you're at.
So I'm going to ask you about footnote 7,
Okay.
and that is on the top of page 16.
Hmm.
Well, not the top, I'm sorry, the bottom of page 16 on the version that I sent you. It's from Westlaw, so I'm using the page number that corresponds to the page we're looking at, not necessarily the citable number.
Okay, so I see it in my testimony and I see it on the bottom of page 16 of the decision.
So, what is the purpose of footnote 7 in the Chesapeake case?
Objection, speculation, foundation.
The foundation is that she referenced footnote 7, gave us a quote from footnote 7, and I'm simply asking why footnote 7? What is even the point of it? Why would you include it? What is it saying?
Overruled.
I do not know what was going through the head of the person who authored this decision.
What do you think?
Objection, speculation.
Overruled. She included it in her testimony.
Well, I think that in part, this particular footnote talks about the overlay of environmental protections that utilities must meet, that they can be quite significant. And then I think, interestingly, for me at least, you know, the last sentence in which it talks about how the law has become part of our daily lives. And in this sense, the awesome power of the enforcement, while haphazard, collectively is no longer out of the ordinary. And so the way I interpret this is that the decision recognizes that certain environmental regulations can have broad, sweeping effects. They can have far-reaching effects. They can be of significant magnitude, and they can have awesome power. And so while that is something that is quite clear, we cannot ignore and we cannot act as though we're in a vacuum and act as though these kinds of regulations are not incurring and do not have an impact in the rate making realm.
Footnote 7 is particularly referring to CERCLA, the CERCLA. Is that correct?
Correct.
And do you see where it says, so I'm looking at the end of the second line of footnote 7, where it's talking about CERCLA has imposed, and this is a quote, the most tyrannical laws imposing civil liability ever enacted in this country, imposing as they do retroactive strict liability. Do you see that?
I do see it.
So you reference in your testimony the SDWA, the Safe Drinking Water Act. Is that correct?
I do.
Is the Safe Drinking Water Act another law that is, quote, the most tyrannical law imposing civil liability ever enacted in this country, imposing as they do retroactive strict liability?
I make no such statement.
Well, I'm asking you now. Is the Safe Drinking Water Act similar to the court's understanding of CERCLA, CERCLA, that it is a tyrannical law well, probably the most tyrannical law imposing civil liability and retroactive strict liability. Is that comparable to the Safe Drinking Water Act?
Trying to find, I want to go back to my testimony where I talk about the Safe Water Drinking Act. Just give me a minute. So I don't think that I would substitute in this idea that I think where you're going with this is that somehow these PFAS requirements are to be substituted in directly for this word CERCLA in this footnote. And I do not agree with that assertion. I also do not agree with the assertion that this is somehow the most tyrannical law put into place. Um, it is clear that what we're talking about in terms of the PFAS remediation is not the exact same thing as this retroactive strict liability that's discussed in this footnote. But the issue here is that the Safe Water Drinking Act is in place to protect public health. And this is the first time that MCLs have been established for these PFAS chemicals, which have been determined hazardous to health. And so they are nonetheless significant.
Isn't it true the Safe Water Drinking Act does not have any retroactive liability?
I do not know the answer to that question.
Isn't it true the Safe Water Drinking Act does not have any strict liability?
I'm not an attorney. I do not know.
Instead, the Safe Water Drinking Act has extensive notice requirements. Is that correct?
Again, I'm not an attorney. I do not know.
Going back to your rejoinder testimony, I'm looking at page 22. Lines 14 and 15. In which you state the court sided with the commission, agreeing that the remediation costs were extraordinary. Is that correct?
That is what my testimony says.
Referring back to the Chesapeake case, and I'm particularly looking at the conclusion section. Page 9 on the document you have, I believe.
9 or 15?
My apologies, page 15. Part 6 conclusion.
Okay.
At any point in their conclusion, did the court say that they agreed with the commission?
Can you repeat the question?
So the statement you made in your testimony is that the court sided with the commission, agreeing that the remediation costs were extraordinary. And so I'm
Okay.
asking you, in the court's conclusion, did the court say they agreed with the commission?
That is not in that conclusion paragraph.
Is it anywhere to your knowledge in the case where the court says they agreed with the commission?
Well, the issue at hand in this particular proceeding was whether or not to allow the recovery of unamortized carrying costs. I believe that really the discussion between extraordinary costs was really dealt with in terms of developing the rider for these remediation costs, and that the decision to implement a rider for such significant costs for environmental remediation, that was not an issue in this particular proceeding. So the commission was not there to agree or disagree with the extraordinary nature and therefore the surcharge mechanism. It was simply about whether or not the commission erred in allowing the carrying costs for these unamortized amounts.
So your statement from your testimony, which says the court sided with the commission agreeing that the remediation costs were extraordinary, is not correct?
If you can give me some time, I can word search through this document.
Go ahead.
Subject check, I don't know, and I do not see a discussion of extraordinary in that conclusion.
Now, in that case, did the court ever rule that allowing a rate rider was the correct way to deal with an extraordinary expense?
That was not an issue in this case.
Thank you. That's all I have.
DPA,
Nothing from the DPA.
redirect.
Thank you, Your Honor. Ms. Hatch, looking at the Chesapeake Utilities decision, can I ask you to turn to page 9, I believe, of the document?
Mhm.
In the document that you have has 2 columns on each page, correct?
Yeah.
Okay. You turn to page 9 of that document. There's a section C, the analogy to cash working capital. Do you see that?
Yeah.
I'd like you to look at the paragraph immediately above that that starts with "in the court's opinion." Do you see that?
Yes.
Can you read the second sentence of that paragraph, please, starting with "even reaching"?
Yes. It says, even reaching the issue, the commission's decision that the remediation expenses and all related costs are extraordinary expenses is supported by substantial evidence and free of legal error and must be affirmed.
What does the word affirmed mean?
I'm not an attorney, but I think it means supported or agreed with.
Thank you. No further questions.
Okay. Thank you, Ms. Hatch.
Thank you.
Is the company prepared to call its next witness?
I believe so, Your Honor.
Your Honor, can we take like a 5-minute break?
A 5-minute break. And I assume Ms. Fetcher will be the next witness?
Yes, Your Honor, that's correct.
Okay, we're going to take a 5-minute break. Back on the record. Okay, we're back on the record, and I'm going to ask the company to call its next witness.
Thank you, Your Honor. The company calls Ms. Gayla Fetcher, who is appearing via Zoom this morning.
Ms. Fletcher, could I have you raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalties of perjury.
I do.
Good morning, Ms. Fetcher.
Good morning.
Do you have a copy of your rejoinder testimony in front of you?
I do.
And if I were to ask you the questions in that rejoinder testimony again this morning, would your answers be the same as they are in that document?
They would.
Do you have any changes or corrections to that rejoinder testimony?
I do not.
Thank you. At this point, Your Honor, the company would move for the admission of Ms. Fetcher's rejoinder testimony as Exhibit 92.
Any objections, staff?
Given Your Honor's ruling this morning as well as on Monday, staff has no further objection.
EPA?
No further objections, Your Honor.
Ms. Fetcher's rejoinder testimony is admitted as Exhibit 92.
Thank you. No further questions on direct, Your Honor.
Staff Cross?
Thank you, Your Honor. Ms. Fetcher, can you hear me clearly?
I can indeed.
Thank you. Good morning.
Good morning.
Ms. Fetcher, are you an accountant?
I am not.
Do you have an accounting degree or accounting certification?
I do not.
Are you an expert in rate setting procedures for regulated utilities?
I am not.
Do you have your rejoinder testimony in front of you?
I do indeed.
If you could please turn to page 3, line 15, and let me know when you're there.
I am there.
So I'm going to read the question beginning on line 15 and then the answer that follows. Question: based on your knowledge of operations and the information the company provided, how do these replacements occur in practice? Answer: replacements occur at the individual skid level and are operationally driven. They are performed on a staggered, ongoing basis rather than all at once. Do you see that?
I do.
So the replacement of the PFAS media by the company will be done as part of the ongoing operations of the Stanton water treatment plant, correct?
Until PFAS is removed from the source, yes.
So the replacement of the PFAS media will be an ongoing operating expense of the Stanton water treatment plant, is that correct?
Yes.
Okay. Thank you. No further cross from staff.
EPA?
Briefly, ma'am, I'm staying on page 3 here. Towards the bottom, the question is asked, based on that, is it reasonable to conclude that all vessels would be replaced within a single 6-month period, as Mr. Watkins seems to assert? And your answer on lines 21 and following says, no, that would not be consistent with how replacements are planned or performed. Ma'am, my question is, could these replacements have been performed in 6 months?
In some scenarios, a given operation may decide to do that. However, that depending on the demands, there may be an inefficient use of media should all the vessels be changed out with that frequency. It would be 100% for efficient change outs. It's 100% determined by demand and quality variables and the corresponding water quality samples that are taken to determine that the media has reached its absorptive capacity.
Okay, so if I understand correctly, there's certain factors in place, but my question is, could this occur within 6 months, as Mr. Watkins suggests in his testimony?
That is not the intent of the operation in Veolia, Delaware.
Sorry, I understand that's not the intent of Veolia, but could it have occurred?
Historically, there would have been no reason to do that so far. There would have been no reason to change out the media yet because the media had not reached absorptive capacity, and any attempt to do so at this specific facility would not have been a prudent expenditure.
Okay, no further questions.
Redirect.
Thank you, Your Honor. Ms. Fetcher, I believe, do you recall when Mr. Ferguson asked you if you were a rate-making expert?
I do.
For your testimony, you are not taking any position as to rate-making components of the media changeouts, correct?
Correct. The only position I am taking is as to their necessity and whether or not the costs are known and measurable, which they are.
Thank you. No further questions.
Thank you, Ms. Fetcher. Next witness, company.
The company would like to call Mr. Harold Walker, who will be appearing via Zoom this morning. I believe he is on the Zoom, Your Honor.
Okay, there he is. Would you swear in Mr. Walker, please?
Mr. Walker? Mr. Walker, can you hear me?
I'm sorry. Yes,
Have you
I'm
raised your
sorry.
hand?
Yes,
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalties of perjury.
I do.
Good morning, Mr. Walker. How are you?
Good. How are you?
Good, thank you. Do you have a copy of your rejoinder testimony in front of you?
I do.
If I were to ask you the questions contained in that rejoinder testimony this morning, would your answers be the same?
Yes.
Do you have any changes or corrections with respect to your rejoinder testimony?
I do not.
Your Honor, at this point, the company would like to offer the rejoinder testimony of Mr. Walker as Exhibit 93.
Any objections, staff?
Same as with Ms. Fetcher. There are no further objections from staff.
EPA.
No further objections, Your Honor.
The rejoinder testimony of Harold Walker is admitted as Exhibit 93.
No further questions on direct, Your Honor.
Cross, staff.
No cross from staff.
DPA, cross.
No cross from DPA.
Okay. Thank you, Mr. Walker.
Thank you.
The company's next witness is Ms. Jana Labella. Yes, she's on the Zoom.
Ms. Labella, could I have you raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalties of perjury. You're muted.
Sorry, I do.
Good morning, Ms. Labella. How are you? Can you hear me?
Good morning. Yes, I can hear you. I'm good, thanks.
Thank you. Just make sure to keep your voice up a little bit, okay?
Yes.
Thank you. Ms. LaBella, do you have a copy of your rejoinder testimony in front of you?
Yes, I do.
And you prepared that rejoinder testimony for this proceeding, correct?
Yes, that's correct.
If I were to ask you the questions contained in that rejoinder testimony again this morning, would your answers to those questions change?
No.
Do you have any corrections to the rejoinder or omissions from the rejoinder testimony that you would like to address?
Yes, I have one correction on page 3. And that's footnote 4. I would like to replace after word at. So at 10, column 4-7, I would like to replace that with 15, column 1-9. So page 15, lines 1 through 9.
Thank you. Any other corrections?
No, that was the only one.
Okay, thank you. Your Honor, at this point, the company would move for the admission of Ms. LaBella's rejoinder as Exhibit 94.
Any objections, staff?
No objection.
DPA?
No objection.
No further questions on direct, Your Honor.
Okay. The conditional rejoinder testimony of Ms. LaBella is admitted as Exhibit 94. Have we completed all the company's witnesses?
We do. I don't know if staff or I believe DPA has.
I have some questions, Your Honor,
Oh, okay.
but staff may have questions.
Staff has no cross questions. for
Okay.
Ms. LaBella.
DPA?
Or Ms. LaBella, can you hear me okay?
Yes, I do.
Okay. I'm looking at page 5 of your rejoinder testimony. Line 10 says, are the resulting rate case expenses discretionary or avoidable? And your answer, line 11, says, no, these costs were not discretionary. The level of rate case expenses were incurred in response to the breadth and complexity of the issues. And then you go on to say that on lines 14, the company does not control the issues raised, but it does have an obligation to respond to them. And the resulting costs are a function of that obligation. The company controls what witnesses it decides to call, correct?
That's correct.
And the company controls what law firm it decides to hire, correct?
Yes, that's correct.
And it controls how much they're per the contract with that law firm, how much they're willing to spend on the case, correct?
Well, I can't answer that question as a yes or no. I guess the work is normally like for any consultant, usually goes through bids. So
Okay, but ultimately the company has the final say about whether or not they're going to agree with a contract with one expert or one law firm versus another, correct?
right, that's correct.
And you make a cost benefit analysis about that, correct?
What do you mean by cost benefit analysis? Is that the third party cost benefit analysis?
Well,
or
no,
is that
I'm
something
talking
internal?
more in terms of the cost that it's going to cost the company incurred in that case, in terms of how expensive a consultant is or how expensive their legal fees may be with that certain law firm.
Well, it depends on the issues raised. Because if you're talking about just the legal cost, because for all other consultants, they're separate contracts. Some
Right.
contracts that do not exceed, some contracts have an hourly rate.
Okay. So, I mean, for example, in here you said it was not a good comparison to talk about the level of attorneys or consultants in this matter. And you said that was a red herring, correct?
Right, that's correct.
Why is it a red herring?
Because we do have different obligations. Company, staff, DPA. Company has an obligation to present its entire case for completeness of the record. Company is obligated to respond all data requests or any other requests that come from other parties. DPA and staff don't have that obligation. They can pick and choose topics that they would like to focus on. And on other topics, they don't provide any opinions. For
Well,
example, in the, let's say, DPA's case, certain topics were not discussed in Mr. Watkins' testimony. He just used the test period actuals. In staff, for example, testimony, they did not provide an opinion on depreciation rates because that was outside of the scope of Ms. Arazat's agreement, and there was no other witness retained to provide that testimony. With that said, they don't have an obligation to present a witness for each subject that's being discussed in a rate case.
okay. And then on page 5, you talk about on lines 18 and following, you say, I'm quoting, at page 9, lines 23 through 25 of his rebuttal testimony, Mr. Watkins states that while rate costs are a legitimate business expense, they benefit shareholders and not ratepayers through the establishment of increased revenues and profits. And you disagreed with that statement, correct?
That's correct.
Okay. But in a rate case such as here, the primary benefits of an increase are going to be the company and shareholders, correct?
Well, as I stated in my testimony, rate cases are intended to ensure just and reasonable rates that allow the utility to recover responsibly incurred costs and obtain the financial resources necessary to provide safe and reliable service.
That's not my question, ma'am. Primarily, though, in a rate case, who is reaping the benefits if there's an increase?
Both customers and the shareholders.
And the company, correct?
Right. When I say shareholders, as a company.
Okay. But the customers are going to have to pay more if an increase is granted, correct?
Well, when you say more, as part of the cost of service, rate case expense in general, yes, it increased the rates.
So is your
But
testimony?
there's a benefit to it too, because if the company can recover its cost of service, it has money to invest in infrastructure, and infrastructure in the state of Delaware, it's pretty old. We all know that.
Is it your testimony today that as a result of a rate increase granted by the commission, the customers and the shareholders are equally benefiting?
I didn't say equally benefiting. They benefit in their own way. Company benefits from getting a rate relief, and the benefits is the financial health of the company. Customers are getting safe and reliable service.
Okay, but in terms of the primarily who is reaping the benefits?
Well, there's no analysis being done saying, well, the 45% is the customers, 55 is a company. There's no such an analysis. It's just in general that's how it works. Both parties benefit. It's just they benefit in a different way. If the company is financially healthy, they can provide safe and reliable service because they do have finances to finance their operations appropriately. And that's the benefit the customers are getting. It cannot be, calculated saying, well, this is the dollars that are going to customers versus the companies.
Okay, so are you saying that the company wasn't able to provide safe, reliable services previously?
Well, we never had to. I was not involved in any litigation before. Usually in a settlement, the parties agree on the appropriate amount that would allow company to recover its cost of service. And if company at any point sees that the revenue they're recovering through current rates is not sufficient to cover its cost of service, that's when the company comes back with a new rate case.
Okay. in your testimony, you mentioned periodically that the company manages its resources prudently. Recall that?
Right.
Okay.
Probably. It is somewhere there, yeah. But that
Yeah,
would be-
I'm looking at page 4 specifically. And in your testimony, you reject any idea that the company may have overly spent on its witnesses or its legal fees, correct?
That's correct.
Okay. Does there come a point at a time in which the company or a company in general will have overspent on their consultant fees or legal fees?
I don't understand your question.
Well, my question is, so part of Mr. Watkins' testimony is that some of the costs and fees that the company has incurred seems rather excessive. And in your testimony, you says that's not true at all. Is there a threshold in your mind in which a company spends too much money?
Well, when you say excessive in comparison to what? Comparison to another litigation or in comparison to a settled case? Because these are two different scenarios. Settled cases cost a lot less in general than litigated cases. And litigated cases are dependent on the scope of issues that are being raised by other parties. So you cannot compare this case to another company's case or Veolia's previous litigated case because the scope might have been different.
Okay. But so here, Veolia had 7 attorneys involved in this case. That does not seem excessive to you?
I don't think it's 7 attorneys. It depends on the hours that are being billed to us.
Okay. Okay. All right. I think those are all my questions at this time.
Redirect.
No further questions, Your Honor.
Okay, thank you.
Thank you.
Where do we go from here in terms of it's 11:20? Are we going to go to Ms. Azad or are we going to go to Mr. Watkins?
That's whatever the parties agree. I don't know what the witnesses' schedules are like, so
To you, Your Honor.
ultimately it's up to you, Your Honor. But I don't know if
The only request I have is just a very short 2-minute bathroom break before we change witnesses. It doesn't matter to me, the preference, but
Okay, let's take a 5-minute break first. We are back on the record, and I'm going to ask the public advocate to call its witness, please.
good morning again, Your Honor. At this time, the public advocate calls Mr. Glenn Watkins to the stand.
Watkins, could I have you raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalties of perjury.
I did.
Morning, Mr. Watkins. Can you hear me okay?
Yes, I can. Thank you.
Good. Okay. Mr. Watkins, back on December 3rd, when there was still a lot of snow outside, you provided a direct and cross-examination testimony in this matter, correct?
Yes, sir.
Okay. And subsequently, on March 6th of this year, you filed surrebuttal testimony in this case, correct?
I did. Yes.
Okay. And if I were to ask you the same questions today as are in your surrebuttal testimony, would you have any changes or corrections?
No.
Okay. At this time, I'd ask that Mr. Watkins' surrebuttal testimony be marked as, what exhibit are we up to?
we would be on
What's that?
95.
95, Your Honor.
Any objection from the company?
No objection.
Staff?
No objection.
The surrebuttal testimony of Glenn A. Watkins is admitted as Exhibit 95.
Those are all my questions for Mr. Watkins at this time.
Okay, I'm going to turn to the company.
Thank you, Your Honor. Good morning, Mr. Watkins. How are you?
I'm doing well. Thank you.
Mr. Watkins, you had the opportunity as part of this case to review the direct testimony by company witness, Mr. Cagle, correct?
Yes, it's been some time, but I did review it.
And in fact, you referenced that testimony in your SIR rebuttal, page 1, lines 12 through 17. Is that right?
I believe that's correct. Yes.
Okay. And you also, I believe, had the opportunity to review Ms. Hatch's rebuttal testimony, where the company proposed a revised mechanism for PFAS O&M compared to what Mr. Cagle proposed, correct?
Yes.
Okay. Under the revised proposal that was set forth by Ms. Hatch, would you agree with me that the company would incur PFAS O&M costs before they are spent?
I apologize. Could you repeat that, please?
Sure. My question is, in Ms. Hatch's revised proposal for the PFAS O&M mechanism, would you agree with me that under that proposal, as it's suggested, the company would incur the PFAS O&M costs before they seek recovery of those costs from the commission?
I'm going to say yes with the qualification, and I don't mean to be overly nitpicky. And one needs to understand the difference between incurred and paid. They're going to incur a cost and book it on their financial records, and then when they pay that incurred cost, that's going to offset what has been booked to incurred. But I think for purposes of this discussion, I'll agree with what you said.
Okay, thank you. And it's your understanding that under Ms. Hatch's proposal, after they spend that money for the PFAS O&M costs, they would then present those expenditures to the commission for review by staff and DPA for a prudency review with the potential for them to then be passed on as a surcharge. Is that your understanding of the proposal?
Yes, and that is, I believe it's once every 6 months or so, maybe once a year, but that is my understanding, yes.
Okay, thank you. In your testimony at your SIR rebuttal on page 2, lines 1 to 2, you reference deferred accounting and you indicate, quote, Veolia would establish a deferred expense account, presumably the estimated annual PFAS O&M expense. Do you see that or recall that?
Yes, I do.
Can you identify for me where in Ms. Hatch's testimony it indicates that the deferred accounting was related to the estimated PFAS O&M expense on an annual basis?
I don't have her rebuttal testimony in front of me, and if I misinterpreted things, I apologize. The way she worded it, the way I interpreted the company's proposal is they will first book what annually they're expected at this point in time, $3.5 million of expense. They'll establish a deferred expense or reg asset, if you will, and then that will be down by the actual expenses that they pay. If my understanding is incorrect, I apologize and I stand to be corrected, but that's the way I interpreted the rather terse explanation that she gave in her rebuttal testimony. So I'm happy to rescind that if that is incorrect, but that's my understanding of the company's proposal.
Thank you. And that leads to my next question, which is, you would agree with me then that it's possible that the deferral would be for those costs as they're actually spent rather than estimated, correct?
Yeah, I don't like to look in possibilities. I'm just, if that's what the proposal is, I wish they would put it, we can get it straight somewhere in the record. If that's what the proposal is, I'll accept that. I can't say with certainty in interpreting the way her testimony was written.
Okay, thank you. Mr. Watkins, would you agree with me that the company has the burden of proof in this proceeding?
That's my understanding.
And I believe you were on the Zoom just a few moments ago when your attorney questioned Ms. Labella, correct?
Yes, I was listening.
And do you recall the line of questioning and testimony concerning the fact that staff and DPA can, pick and choose the issues that they'd like to contest or seek more discovery on in a proceeding like this?
To some degree, yes. I disregard to the disagree with the long colloquy that the company gave. I mean, all of this goes around to the incremental additional costs that were incurred for rate case expenses, including the additional expert witnesses, the additional legal fees, et cetera. She goes on this diatribe about having to respond to discovery and all of that. We get that. That's in every case. That had been done before. We got into the surrebuttal phase of this case, or even before the rebuttal phase of this case. But to a certain degree, as far as my involvement are concerned, I don't pick and choose. Well, to some degree, I do. I have a limited budget. I don't worry about a $500 expense here and there. I try to pick the most important, both in numbers and policy-wise issues to address.
Thank you. By way of example, isn't it true that essentially DPA has taken no position on the capital costs associated with the company's Stanton water treatment plant in this case, or in fact has allowed those costs? Isn't that correct?
I wouldn't say I have allowed those. I took no position, the former, not the latter.
Okay, fair enough. Would you agree with me that staff has taken a position on those costs?
I think that's pretty clear with everybody.
Okay, thank you. On page 10, line 2 of your rebuttal testimony, and if you need an opportunity to get there, just let me know.
No, Simon, thanks.
Okay, thanks. On that page, you acknowledge, quote, that you have not attempted to itemize the individual components, end quote, of the company's additional amount in rate case costs, but you recommend allowing only 50% of that amount, correct?
That's exactly correct. And
okay. And are you aware?
Let him finish his answer there.
No, go ahead, Simon. I'll give you a speech in a minute.
Are you currently aware of any effective Delaware statute or regulation that allows only 50% of a company's rate case expenses? Yes or no?
Statutes, no. Regulatory practice around the country and perhaps in Delaware, I can't remember. But it is common for a commission to use its judgment, informed judgment, as well as experts, to not quantify to the penny certain aspects. Maybe they'll give 75% recognition or whatever, because a lot of this stuff, you don't want to nitpick, did you personally bill too much? Did you bill 3 hours too much? Did the consultant bill, $5,000 too much? I didn't want to try to get everything down to the penny in making my recommendation. With that being said, I do recognize there were prudently incurred and reasonable costs in addition to what the company proposed in its initial filing. I agree with that. So that's why I did not disallow all of it. But some of your witnesses characterized my recommendation as arbitrary. Arbitrary is something based on a whim. No, it was not a whim. I fully recognize that there are some prudently incurred costs that should be recovered from ratepayers. Did I put it down to every single penny? No. So I said, what seems fair to me, to ratepayers and to the company, is to give them half. I didn't take an overly aggressive position. So it certainly was not arbitrary. It was based on informed judgment.
Thank you, Mr. Watkins. And I think in that answer, you agreed with me that you're not aware of any Delaware statute or specific regulation allowing or requiring a 50% decrease of rate case expense. Is that correct? You're not able to provide me a citation to any statute or regulation?
Not off the top of my head, nor have I done any research to determine that either way.
That's fair enough. Thank you. Are you aware of any order or precedent from the Delaware Public Service Commission where the commission applied a 50% reduction to rate case expenses?
Again, same answer. Not that I recall, but I have not done that research.
Okay, thank you. On page 10 of your sir rebuttal testimony, I'm specifically looking at lines 1 to 2 of that. You state there that, quote, "This case has become lengthy and complex." Do you see that or recall that?
Absolutely, yes.
And do you continue to agree with that assessment?
It's a matter of fact, not opinion, yes.
Would it be fair to say that increasing complexity would reasonably require additional legal and expert resources that could increase cost?
Yes, and that's why I've given you half of it.
I'm going to object that that's a slight mischaracterization of the testimony. He talks about costs incurred by Veoila were largely brought on by itself. This is not just a vacuum that this case has become lengthy and complex. Mr. Watkins' testimony here is talking about what Veoila has decided to do.
Sustain.
Mr. Watkins, would you agree with me that the company was entitled to file rebuttal testimony, filing staff and DPA's direct testimony?
Absolutely, that's customary.
And so the company's actions in responding to positions raised by staff and DPA, the associated rebuttal costs of that response would be a normal part of litigating a rate case, right?
Yeah, but the key word is normal. You know, you guys are requesting to more than double, maybe even more than that, your rate case expenses. And as indicated in my testimony on in my short rebuttal testimony, excuse me, as acknowledged by the company themselves in the rebuttal testimony of Ms. Hatch, pages 6 and 7, the company brought a lot of these additional costs on by themselves. Typically, rebuttal testimony is relatively short in the sense that it provides rebuttal to individual issues, but does not double the cost of their expenses. And in fact, if we look at page 6, table 1, we say that the projected legal expenses went up from $30,000 to $600 to increased by more than $650,000 to almost $1 million. My arithmetic's not very good in my head, but that's what, a 20 times increase in legal expenses brought on largely because of its inability or refusal to respond to staff's data requests. And that's exactly why, in my opinion, the company should not seek recovery from ratepayers of 100% of all of these costs, but rather half of them.
Thank you. And do you recall in this proceeding, Mr. Watkins, when, at what point or stage or phase was it first discernible, for example, that staff was taking the position that it would not be allowing recovery of we'll call it the PFAS-related cost? When did that become apparent?
Apparent to me or apparent to the commission?
Apparent to you.
I would say.
I don't want to know anything that you discussed with your attorney or anything like that.
No. I'm pretty sure this is pretty accurate. I would say about a week before pre-filed testimony was due, Mrs. Odd and I had a short conversation of where we are on our testimony and what our adjustments were going to be. So it was about a week before we filed pre-filed direct testimony, somewhere in that ballpark.
And then in turn, would you agree with me that that intention was then communicated to the company through staff's pre-filed testimony?
Yeah, I think that's pretty obvious. Yes.
And then in response to the pre-filed testimony, the company had to retain additional witnesses, correct?
That's your opinion, not mine.
Okay, but it's a fact.
They didn't have to. They did not have to. That was your decision.
Okay. Would you agree with me, Mr. Watkins, that the company does not have decision-making authority over the consultants hired by staff or DPA in this matter?
Once again, I apologize, Simon. One more time, please.
Sure, no worries. My question is, would you agree with me that the company does not have authority or decision-making authority with respect to the consultants that are hired by staff and DPA?
Oh, yes, I would agree with that.
Okay. And same question, but related to the expenditures that those witnesses charge. For example, the company does not have an input into what your rate is in this proceeding, correct?
Yes, with one equivocation or qualification. As far as our hourly rates go and what I charge DPA or staff charges, consultants charge its staff. Clearly, we both have control over that. But then the question then is, do they then charge that back to the company, those expenses for consultants, legal fees, whatever? And this is what I don't know. Is there any recourse to the company if they feel that those are excessive? I frankly don't know.
Fair enough. And that's fine. And certainly we don't want you to answer any questions that you don't know. But my question is more along the lines of the fact that, and again, I don't want to know anything that you discussed with your client, the DPA, or potentially with staff. But in terms of when you were discussing your retention in this matter with the DPA, were you corresponding also with the company as to what your rates would charge or what your contract would be structured as?
No.
Okay, thank you. I have no further questions.
Cross staff.
Just one quick question, Mr. Watkins. In your opinion, why did this case become lengthy and complex?
Well, I think it's eminently clear to everybody that PFAS related issues, are the focal point of the case and where we are today. But with all due respect, I worked very closely with the company. I appreciated everything they did informally, but by the company's own acknowledgement, they did not adequately respond to Mrs. Odds and the staff's data request, which really made it difficult for both the Azads to complete their analysis. And then, right, wrong, or indifferent, the company then decided to spend another $1 million trying to defend itself from not adequately responding to discovery early on. So that's my opinion.
No further questions.
Redirect DPA.
Briefly, one or two questions. Mr. Watkins, I think it was in Ms. Fetcher's testimony earlier. She talked about rate making being a mix of art and science. Do you recall that?
I believe it was
Yes.
Ms. Hatch's testimony.
Ms. Hatches, my apologies.
I do remember.
And do you agree with that?
Absolutely.
And could you elaborate a little bit on that?
Yes, I think Ms. Hatch did a good job on it. It's rate making is not simply a matter of accounting or pushing a button and out comes the answer. It involves considerable expert judgment on a myriad of facts, prudency, timing, prior practices, the commission rules, the administrative code, et cetera, et cetera. And then, perhaps most importantly, and I think this is where Ms. Hatch was going, it does involve a matter of subjective, informed expert judgment. It's not a matter of the slide rule. So I agree wholeheartedly with what she said.
Okay, thank you. Those are all my questions.
Okay. Thank you, Mr. Watkins.
Thank you, Your Honor.
I have one question.
Okay. One question, Mr. Watkins.
No, not for Mr. Watkins.
Okay. Can we go off the record? Let's go off the record. Good afternoon. We have returned from lunch. It is 12:46 p.m. and I'm going to ask staff to call its witness.
Staff calls our witness Ara Azad.
Could I have you raise your right hand? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalties of perjury. And you're on mute.
Good afternoon. Can you hear me okay?
Yes.
Thank you. Yes, I do.
Mrs. Odd, can you hear me okay?
Yes.
In front of you, do you have a copy of your rebuttal testimony in this matter?
Yes.
And today, do you affirm your rebuttal testimony as presented?
Yes.
Do you have any changes to your testimony?
No.
Your Honor, at this time, I would ask that the rebuttal testimony of Ara Azad be moved into evidence as Exhibit 97.
Any objection, company?
No objection, Your Honor.
DPA?
No objection, Your Honor.
The surrebuttal testimony of Mrs. Odd is admitted as Exhibit 97.
Staff has no further questions for Mrs. Odd.
Company? Cross?
Thank you, Your Honor. Good afternoon, Mrs. Odd. How are you?
Good afternoon. Doing well, thank you.
Thank you. In your surrebuttal testimony, you have that in front of you, correct?
Yes.
Can you please turn to page 10, lines 5 through 8? There, in relevant part, the question is, what is the guidance you have relied upon in providing staff's recommendations in this docket? Answer, excuse me. Answer, I have assumed the business judgment standard, the less stringent of the two standards in effect during the term of this proceeding, based on the date of Veolia's initial filing. Do you see that?
Yes.
So is it fair for me to infer from that statement that you are assuming that the business judgment standard applies to the company's requests in this proceeding, correct?
Yes.
In your surrebuttal, page 5, lines 24 to 28, if you could turn there for me, please. There, in relevant part, you state that your formal education, degrees, and certifications were predicated on successful completion, among other subjects, of coursework in business law, logic, and critical thinking, regulations, fraud examination, financial accounting, and managerial accounting. You then state, my knowledge from this educational framework informs my assessment of what constitutes rational decision-making in a business. Do you see that?
Yes.
Mrs. Ott, have you ever been employed by a water utility?
No.
Have you ever served on the board of directors of a water utility?
No.
Have you ever served on the board of directors of any utility?
No.
Have you ever served on the board of directors of any company?
No.
Thank you. Mrs. Odd, would you agree with me in this case that one of the drivers behind the company's PFAS treatment efforts that the company is citing is regulatory changes?
Objection. That's outside the scope of this proceeding. We're here to talk about the PFAS O&M surcharge mechanism.
Overruled.
Would you like me to repeat the question?
Yes.
Thank you. Would you agree with me that one of the drivers that the company is claiming behind its PFAS costs is regulatory changes?
Yes.
Would you also agree with me that another driver the company is citing is the need to provide safe drinking water?
Objection. Mrs. Ott is not qualified to talk about safe drinking water.
I'm not asking her that. I'm asking her if it's her understanding as why the company is claiming the need to incur these costs.
Overruled.
Can you point me to specific testimony where that's cited?
Do you have a general recollection in this case, Mrs. Odd, whether the company has claimed that they are pursuing these PFAS investments, among other reasons, to provide safe drinking water to its customers? Is that something that you've heard in this proceeding before?
I'm not sure.
Okay. Can you turn to page 24 of your SIR rebuttal, starting at line 8, please?
Yes.
And continuing from page 24, line 8 to page 26, line 4, you discuss the change out costs of the media, and you note in there, specifically in your footnote 32, the final sentence, that the primary variables of costs are, the primary variables are cost of the media and freight in and freight out, correct?
Yes, that's what that says. The primary variables are cost of the media and cost of freight in and freight out.
Okay, thank you. And do you recall in this proceeding hearing testimony or reviewing the company's contract with Calgon for PFAS media treatment?
Not specifically.
Okay. If I represented to you that the company has a price-locked contract with Calgon for PFAS media through 2027, would you have any reason to disagree with that statement?
No, subject to check. No.
Sure. I want to make sure that I'm understanding your position with respect to the change-out costs correctly. Is it your position that the costs associated with the PFAS media changeouts are not reasonably known and measurable because the exact dates that the changeouts will occur are unknown? Is that correct?
Objection, mischaracterizing her testimony. There's no need for an exact date.
Overruled.
No, I don't agree with your characterization.
Okay, can you please explain your position on this company? Please explain your position in this proceeding as to what level of exactitude is required as to the dates of the changeout.
No, I don't provide an opinion as to what those dates need to be. If you look at my testimony on the pages that you referenced, starting on page 24, I explain a number of factors that should be taken into account when determining what is and is not reasonably known and measurable. And I don't specify the exact dates in particular, but more broadly explain what the elements are and if any of those elements that are necessary are not known and measurable. If when you've got two numbers, the product of which is what we're trying to determine, if either of those inputs is not known and measurable, the product of those two things is not known and measurable.
And for clarification, you're referring, I think, specifically to page 24 of your testimony where you provide an equation or formula with the A times B equals C variables in there. Is that what you're referring to?
Yes.
Okay. And as I understand it, in that formula, you have A as the dollar amount attributable to each media changeout, B is the frequency of the media changeout during the year, and C is the annual cost of the media changeout. Is that right?
Yes.
Did you obtain this formula from any Delaware statute or regulation?
No.
And did you obtain this formula from any decision of the Delaware Public Service Commission?
No.
So you developed this formula yourself, correct?
Yes.
If the frequency variable in this formula, which is B, were replaced with a value, in other words, 1, and the other variables also had value, would the cost then be known and measurable in your opinion?
I'm not following your question.
Sure.
If the,
As I understand your testimony, it's your opinion that the PFAS media changeouts are not known and measurable because the company is not able, in your opinion, to been able to provide a level of frequency at which the media changeouts occur. Is that right?
not entirely. The way that you stated it mischaracterizes my testimony, that it leaves out the other nuances or all of the relevant nuances that are necessary.
Sure. So I'm sorry, were you finished?
I was going to say, for example, frequency of media change out during the year would have to be known and also reasonably representative of normal operating conditions. I discuss all of those other factors.
Sure. And that's what I'm trying to figure out. I'm trying to unpack your equation here. Because in your equation, the outcome, the variable of C, which is the annual cost of the media changeout, in your view, is dependent on A, which is the dollar amount attributable to each media changeout, and B, the frequency of the media changeout during the year, right?
Yes.
So if we know the dollar amount attributable to each media changeout, we just need to take that number and multiply it by how many times the changeout occurs during the year. And then that would provide us with C, correct?
Yes.
Okay. So I think here we've discussed the fact that the company has a price locked contract for the media. So in your mind, is there any dispute as to the dollar amount attributable to each media changeout? Factor A of your equation under the company's price locked contract.
Can you repeat the question?
Sure. I'm trying to figure out, with respect to your equation as applied to this case, A times B equals C, because the company has a price locked contract that sets the price for its media changeouts, is there any uncertainty as to the value of the media changeout under the price lock contract, in your understanding?
I don't know. I would have to review the terms of that contract.
Okay. Do you recall if that contract was provided to you during discovery?
It may have been, and I'll emphasize that it's not pertinent to the conclusion of my rebuttal testimony. Because, like I said, if either of the inputs are not known and measurable, then the outcome is not. And here I have focused my testimony on the fact that we know that element B is not known and measurable at this time. I don't recall all of the details of the contract that you're referencing, and it's not material to the conclusions in my testimony.
Okay. So my question is a little bit different than that. My question is, under the company's price lock contract, does that, well, I guess maybe you answered my question when you said that your equation here for the purposes of this proceeding is only focusing on factor B, the variability of the media changeouts. Is that right?
It's not only focusing on it, but it's primarily highlighting the problem with factor B.
Okay. So assuming we were able to take the price locked values from the company's contract as the variable A, we would then still need a variable B, frequency of the media changeouts, in your equation to determine C, correct?
Yes.
So if we had the value, let's call it, I'm a lawyer, not a mathematician or an accountant, so let's use simple numbers here. So for variable A, if we had a cost of the media changeout, let's just use the number 10, and then we were able to determine the frequency of the media changeout with whatever value that would be, let's say 1 or 2, let's say 2. To keep it simple again, we would have 10 times 2 equals C, 20, correct?
Yes.
So under that hypothetical, if you were able to insert the value of 2 into B, would the cost then be known and measurable?
It depends. It depends on in what context we're looking at known and measurable. Are we looking at what is known and measurable for normal operating conditions or not? So those elements would have to be taken into account at the same time together to determine the context in which that outcome would be deemed known and measurable.
So then what you're saying is that the question you have in your testimony is question, what is required for measuring the annual cost relating to Veolia's PFAS media changeout? Answer, if these costs were known and measurable, one would calculate their dollar impact using an equation simplified as the product C of two factors, A and B, and then you proceed to explain the equation we've already discussed. So now is it your testimony that something additional is required beyond this equation to determine whether the annual costs relating to Veolia's PFAS changeout are known and measurable?
What I'm saying now is consistent with what I have in my testimony, which is that this is a simplification for illustrative purposes. And so it would be misleading for us to not take the context into account when we're looking at an illustrative example like this to simplify what we're looking at.
So if the company was able to provide the value, the dollar amount attributable to each media changeout, the frequency of the media changeouts, which would give us a total annual cost of the media changeout, what additional information is required, in your opinion, to determine whether the cost is known and measurable?
Additional context, including, for example, what constitutes reasonable and normal operating conditions on an ongoing basis. That would be that would be one of the elements of the frequency we would need to consider. The illustrative point of this example is not to demonstrate under what condition we check that box necessarily. The bigger takeaway point here is that if we look at it with this illustrative example simplified, it's easy to see that if one of those elements is missing, then you don't have what's on the other side of the equation.
Okay, and I think going back to something you said just a moment ago, and I do not want to mischaracterize your testimony, so please correct me if I misstate this, but I think you were referring to the additional component of what would amount to normal operating conditions. Can you repeat that for me?
Yes, normal operating conditions.
Okay. And where is your requirement from normal operating conditions being derived from?
Can you repeat your question?
Sure. Do you understand the known and measurable standard to be derived from a Delaware statute or regulation?
In what way? What do you mean when you say derived from?
Where are you obtaining the requirement that the company's costs must be known and measurable? Is that a standard you made up from yourself, or is that a standard that you obtained from somewhere else?
No, it is my understanding that it is in the Delaware Code.
Okay. And I'm trying to figure out if what you're telling me about the requirement that the change-out cost and the frequency constitute normal operating conditions, is that also something you're obtaining from the Delaware Code?
I don't recall where exactly in the code that is or is not explicitly stated. But if any amount gets calculated in the revenue requirement, it is understood that it's supposed to be indicative of normal operating conditions, so as to not disproportionately make the revenue requirement too high or too low in a way that's not representative.
Thank you. In your rebuttal testimony, or surrebuttal testimony, excuse me, you used the term single issue rate making, correct?
Yes.
So the surcharge mechanism that the company is seeking through this proceeding, would that be considered single issue rate making?
Yes.
Would a regulatory asset be considered single issue rate making?
Likely, yes, it typically is. Depending on the, have to tell me the context of it, but that can be one avenue. Yes.
Sure. On page 28 of your Sir rebuttal testimony, specifically lines 22 through 26, you state there, quote, based on analysis from the company's own engineering expert, advance approval of recovery before adequate data becomes available to normalize costs could financially penalize ratepayers on the count of premature filing for base rate increase when reasonable business judgment, would dictate that the utility wait to obtain several years of data to ensure costs passed on to ratepayers represent ongoing normal operating conditions for the rate effective periods rather than potentially anomalous financial data resulting from the lack of adequate information. And that continued on to page 29. Do you see that?
Yes.
Okay. You also state on page 14 at line 9 that, in relevant part, rather than subject these costs to the proper scrutiny of commission staff, application of a special recovery mechanism for this single issue would guarantee Veolia revenues for post-test period costs, serve as a disincentive for cost containment, and would reduce risk without a commensurate reduction to the company's rate of return to account for the reduction of risk. Do you see that?
Yes.
Are you familiar with the concept of a distribution system improvement charge?
Generally, yes. And I don't address that in the context of the Sir rebuttal testimony.
Sure.
Specifically.
When a utility, to your knowledge, when a utility submits for a recovery of DISC costs, are those costs guaranteed in advance?
Objection, Your Honor. This is not about DSIC costs. This is about the PFAS O&M mechanism. Once again, we're veering off into something irrelevant.
It's comparable to a DISC mechanism, Your Honor. I'm getting there in a moment.
He's asking her about statutory regulatory requirements that she does not discuss and is, I don't know if she's qualified to discuss.
Sustain.
Are you aware that under the company's proposal, the company is spending the money for the PFAS immediate costs before it seeks recovery for those costs?
The company is asking approval before those costs have materialized. That's my understanding.
And did you reviewed Ms. Hatch's rebuttal testimony in this case, correct?
Yes.
Did you have a copy of Ms. Hatch's rebuttal testimony handy? Well, actually, you know what? Do you have a copy of her rejoinder testimony handy?
Yes.
Okay. If you could turn to her rejoinder testimony, starting at page 4. Page 4, line 14. I'd ask you to take a moment to read page 4, line 14 through page 5, line 15.
I've read that section, yes.
Okay, thank you. Does that testimony refresh your recollection as to whether the company is incurring the cost before they submit for recovery?
What you're stating doesn't appropriately characterize my understanding of what the company's asking for here. The company is asking for approval now and prior to having those costs materialized. So the request for this mechanism being approved is in advance of the costs being incurred.
I understand that. Is it your understanding that the company is seeking advance approval for the cost before they are incurred, or simply approval for permission to use this mechanism?
Both.
Okay, so it's your understanding that as part of the company's proposal, the company is seeking a pre-approval of costs before they are spent. Is that right?
Could you restate your question, please?
Sure. I'm just trying to understand your understanding of the company's proposal. And what I'd like to know is that under your understanding of the company's proposal, is it your belief that the company is seeking permission to recover the PFAS media costs before the company has actually incurred those costs? Or is the company seeking permission to implement a mechanism as described in its testimony that would permit an avenue to recover those costs?
Well, I think both can be true at the same time.
And I just want to know what your understanding is.
My understanding is that the company is asking approval for single issue rate making for a rider for a surcharge related to this category of costs in advance of those costs having materialized.
Thank you. And under your understanding of the proposal, as set forth by the company, would staff and DPA have an opportunity to review the company's application for costs before the company recovered those costs?
It says here, the way that Ms. Hatch has characterized this, it says, she says, in connection with this filing, staff and the DPA will have 30 days to review the filing for prudence before the surcharge's effective date.
And what do you interpret that as meaning?
That Veolia is giving staff and DPA, according to this, 30 days to review the filing, and then the surcharge will go into effect based on the company's proposal.
Thank you. If you could turn for me in your sur rebuttal testimony to page 15. Specifically starting at lines 11 through 16. And there you suggest that extraordinary costs are comprised of a couple criteria, including that they are non-recurring or infrequent and outside of the scope of ordinary business operations or unusual. And you also suggest that they need to be material, which you describe as substantial enough in magnitude to warrant consideration. Is that correct?
Yes, that's generally consistent with what I've presented here.
Are there any other criteria that you believe should be considered by the commission when determining whether single issue rate making should be allowed?
Yes, I think the commission should consider all of the relevant facts and circumstances.
And would those facts and circumstances also include the public interest or the public good?
Yes, among other things, it should.
In your surrebuttal, you discuss at great length and the Delaware Supreme Court's decision in the Chesapeake Utilities case, correct?
Could you point me to the section in my testimony that you're referencing, please?
Sure, one moment. So if you look on starting on page 18 of your testimony, and then continuing through page 21 of your testimony, you discuss the Chesapeake Utilities case. Do you recall that?
Yes.
Is it your understanding that the Delaware Supreme Court in that case concluded that the commission had correctly determined that the expenses at issue in that case were extraordinary expenses?
I don't specifically recall that, and I don't believe I've made a specific reference to that here, have I? If I have, please point me to it.
No. So what I'm at, you reviewed that case in preparing your testimony, correct?
I did, yes.
Okay. Do you recall the discussion in that case about whether expenses were ordinary or extraordinary?
I don't recall the precise language used.
Sure. Do you have a copy of the case in front of you?
I don't.
Can we go off the record for a second, Your Honor?
Yes, off the record.
Okay, did you provide Mrs. Odd, for the record, you have a copy of Chesapeake Utilities Corporation versus Delaware Public Service Commission, 705 A. 2nd, 1059, 1997, in front of you, correct?
Yes.
And is this the decision that you reference in your surrebuttal testimony?
Yes, in part, this is part of it, I believe.
Thank you. So the question I was asking you before we obtained a copy of this decision was whether it was your understanding in that case, the court concluded that the costs at issue were extraordinary expenses as opposed to ordinary expenses. Do you remember that question?
Yes.
And the copy that you're looking at, it's formatted in a 2-column format. Is that correct?
Yes.
All right. I believe if you could turn to page 9 for me, please. On page 9, in the paragraph above subsection C that starts in the court's opinion, do you see that?
Yes.
The second sentence in that paragraph says, even reaching the issue, the commission's decision that the remediation expenses and all related costs are extraordinary expenses is supported by substantial evidence and free of legal error and must therefore be affirmed. Do you see that?
Yes.
Does that refresh your recollection as to whether the court concluded the costs at issue were extraordinary expenses?
It appears so.
Okay. And do you recall whether the PSC reached the same conclusion? In other words, that the costs were extraordinary expenses?
I don't recall.
I'm going to refer you to that same passage we just read. You could read that passage again and let me know whether that refreshes your recollection as to whether the commission reached a determination as to whether the expenses were extraordinary.
Your Honor, I'd like to object to this line of questioning. It's asking her to interpret the legal finding, and in her testimony, she talks about facts underpinning the decision, how the surcharge mechanism has been treated since then. She's not giving an interpretation of this case, which is what's being asked of her right now. So on that grounds, I would object to it as outside the area of her expertise.
Sustain.
Mrs. Odd, in that case, would you agree that the remediation costs that were at issue there were recurring and ongoing?
Objection. It's the same objection.
It's the facts underpinning the case, Your Honor.
Overruled.
What I've got in my testimony here is that starting on page 18, line 24, one, and the most pertinent material dissimilarity between the two instances is that Veolia has presented its forecast O&M expenses related to PFAS media changeout as ongoing, recurring, and relating to normal operations for Veolia's water treatment plan, while cleanup of MGPs are not ongoing, recurring, normal operational costs for Chesapeake.
If you turn to page 4 of the case, the PD or the document in front of you, on page 4, in the right-hand column, the last paragraph on the page, starting with Chesapeake, having already spent $2.7 million. Do you see that?
Yes.
Okay. The second sentence of that paragraph says, the costs, however, will not be incurred all at once. Expenditures for soil remediation are expected to be made over a 2-year period, while expenditures for groundwater, and it continues on to the next page, remediation could be made over a period as long as 30 years. Do you see that?
Yes.
Does that refresh your recollection as to whether the costs in that case were recurring?
This doesn't necessarily characterize the costs as ongoing, recurring, normal operational costs. The fact that it says, the sentence that expenditures for soil remediation are expected to be made over a 2-year period, while expenditures for groundwater remediation could be made over a period as long as 30 years, doesn't change the nature of the costs necessarily to what would be ongoing, recurring, and relating to normal operations. In the same way that would be analogous to Veolia's water treatment plans for PFAS.
Well, that's not what I'm asking, Mrs. Odd. My question is whether a cost that is incurred over 30 years, is that a cost that's recurring, or is that a cost, a one-time cost?
Neither necessarily. It depends on the context.
So if a cost over 30 years is not a one-time cost and it's not a recurring cost, what kind of cost is it?
I haven't made an opinion as to that here. I've merely highlighted the material differences between the two cases. I'm not providing an opinion as to the characterization specifically necessarily of these costs beyond what I have characterized in my testimony.
You had the opportunity to review both Ms. Hatch's rebuttal and her rejoinder, correct?
Yes.
And do you recall that in both of those testimonies, she provided the figure that the PFAS O&M costs would represent an additional 7.5% of revenue need for the company. Do you recall that?
Can you direct me to the page and line number, please?
Sure, give me one moment. Mrs. Hatch's rejoinder testimony, if you could turn to page 15, please, starting at line 1. It says there, it is undisputed that the estimated 3.5 million in PFAS O&M costs represents about 7.5% of additional revenue need when compared to the company's revised revenue requirement of 46.4 million, which does not include recovery of the PFAS O&M costs. Do you see that?
I see that she has made that statement, yes.
Okay. And to you, that figure, 3.5 million, which would be 7.5% of additional revenue need, is that a substantial figure to you?
How do you define substantial? Substantial would be, yes. How are you defining that for me to answer?
In the normal way that a reasonable person would understand it, meaning significant, whatever the thesaurus says substantial to mean.
It depends on the context and the definition of substantial.
Well, I think the context is provided for you right there in Ms. Hatch's testimony. In the context of the 3.5 million in PFAS O&M costs, representing 7.5% of additional revenue need when compared to the company's revised revenue requirement of $46.4 million, which does not include recovery of PFAS O&M costs. In that context, is 3.5 million representing 7.5% of additional revenue substantial?
I don't take any position as to that definition.
Is it your opinion, I think you express in here, I just want to understand it, that recovery of any new category of costs must be presented by a utility alongside 3 to 4 years of historical data before those costs can be recovered?
I believe that's a mischaracterization of my testimony. Would you direct me to
Certainly.
the line that you're referencing?
Can you please turn to page 28 of your rejoinder testimony? Specifically, I'm looking at lines 6 through 8. It says that I recommend that recovery of any new category of costs, such as the O&M operating costs that may materialize in the future, be contingent on collection of 3 to 4 years of data so as to enable normalization of costs. Do you see that?
Yes, that is what that says.
Okay. Can you identify any Delaware statute or regulation that requires 3 to 4 years of data prior to allowing a utility to recover costs?
I don't recall or know if that's something that's explicitly stated. That is consistent with the way in which Veolia itself has presented a lot of its information in terms of normalization. It is industry standard often that if you've got costs that for which one single year is not appropriately representative of normal operating conditions, that you want to take a look at several years or several periods worth of costs to make sure that you can normalize those costs.
Is that for existing costs or new costs?
Depends on the facts and circumstances. It could be applicable to both, and it should be considered in the context of both.
And so going back, I think your answer to my original question was that you are unable to identify a Delaware statute or regulation that would require 3 to 4 years of data prior to allowing a utility to recover new costs. Is that right?
I don't recall that statute necessarily provides that level of detail per se.
Can you identify any order of the Delaware Public Service Commission that requires the utility to provide 3 or 4 years of data prior to allowing that utility to recover costs?
I haven't done a comprehensive review and I don't recall off the top of my head.
No further questions.
EPA? Staff redirect?
Great. So you remember talking with Mr. Simon about the section in your testimony, pages, I think 18 through 20, where you discussed the material dissimilarities between Chesapeake case and the current PFAS O&M surcharge? You remember
Yes.
talking to him about it? What documents did you use to aid your discussion on the material dissimilarities between the two matters? What I'm getting at is, did you rely solely on the case that you discussed with Mr. Simon?
No,
That's all I have.
thank you.
Okay. Are you done, Miss Workman?
I said I was done and I would not like to go back on my word.
Okay. Okay. I saw some dialogue over there. Okay. Are the parties ready to close the evidentiary record?
Your Honor, I think we discussed this briefly off the record. The company has the settlement agreement with the specific terms that we just need to circulate to staff and DPA for the standard, quote unquote, standard nomenclature. So it shouldn't be too much of an ask. But I think perhaps if we could get that to you tomorrow, would that be? I don't want to put word. I don't know your schedules. If we need to go off the record, we can. But
I mean, we can certainly look at it tomorrow, but if we need to have some back and forth about particular wording, I don't want to commit to tomorrow.
I don't want to do that either.
Maybe give us a week.
That's fine. Okay, so we will not close the evidentiary record today, but we will end today, and it's 1:37 p.m. And thanks everybody for attending today.